Welcome back for the next episode in this series on the match, Part 5, The Lawsuit. In 1998, a small family medicine residency program in Colorado lost its accreditation. For the residents of the program, this was obviously a big deal, but it wasn't the kind of thing that you'd expect to change the course of medical history. And yet, it almost did. Just like the butterfly who flapped its wings and started a hurricane across the world, this seemingly inconsequential incident set in motion events that would change the history of academic medicine and reach to the highest levels of the US government. In parts 1 through 4 of this series, we learned how the match came to be, but here we're going to review how it nearly ended. See, after the Health One family medicine residency program shut down, a few of the residents went to see an attorney named Sherman Merrick. The stories they told him about their working conditions were jarring. Like residents elsewhere, they were working virtually unlimited hours for meager pay. But since they'd received their residency position through a matching process, they'd accepted that contract sight unseen, without any negotiation over salary or hours. And because few residency positions were available outside of a match, transferring to another program was difficult, if not impossible. For the first few years of his career, Merrick had worked in a firm that specialized in antitrust law. The system that the residents were describing didn't seem like it should be legal. At first, Merrick thought, there must be something I'm missing. Even after the Health One residence case was over, Merrick couldn't stop thinking about the strange system that had placed them with their jobs and removed their ability to negotiate for more salary or better working conditions. Was the match legal? The more he thought about it, Merrick didn't think so, and soon he'd get the chance to put it to the test. In 2000, Dr. Paul or P.J. Jung was a fellow at the Johns Hopkins University. He just finished his internal medicine residency at Cleveland's Metro Health Medical Center. As a student and resident, he'd been involved in advocacy and activism. He understood the alphabet soup of medical education and regulation from the AAMC to the NRMP. And one day, he got a call from an attorney that was trying to understand those systems a little bit better. As Jung taught Merrick about the inner workings of the residency placement system, he got to learn about antitrust legislation. For over a century, the Sherman Act had made it illegal for cartels to fix prices or suppress competition. And yet, it seemed clear that that was exactly what was occurring in residency training. Jung agreed with Merrick. The match was illegal. And so, along with two other residents, Luis Lorena and Denise Green, Jung volunteered to serve as a class representative for all residents in a class action lawsuit against the match. And so on May 7th, 2002, Jung and the other residents filed their lawsuit in the U.S. District Court in Washington, D.C. Styled as Jung versus AAMC, the suit alleged a conspiracy among the governing authorities in medicine that served to keep resident salaries low and work hours high. In support of their position, the plaintiffs pointed out several curious things about the resident physician marketplace. For instance, resident physicians worked long hours, often 36 or 48 hours in a stretch. In other industries, that is, in industries where workers could choose their employer or move freely between jobs, you just didn't see employees choose to work that much. For another thing, resident salaries were low. At the time, they were approximately about $10 an hour. But when residents worked outside of their residency program by moonlighting in other physician roles, they often earned the same hourly rate as an attending physician. Resident salaries were stable. In fact, they seemed only to increase at the rate of inflation. If residents were being paid at the market rate, why didn't salaries fluctuate with market conditions? Further, resident salaries were standardized, regardless of the program quality. In a regular job market, a less desirable employer might choose to entice workers by offering a higher salary. But that was something that just did not occur with residency positions. Furthermore, when residency is over, practicing physicians get paid widely varying amounts. A neurosurgeon starts at a salary around 3 times that of a pediatrician. Yet these same market forces don't seem to be in play in residency, where all residents get paid exactly the same. It was very hard to imagine how this set of circumstances could arise in a free market system in which doctors and hospitals negotiated with each other freely. And so, to explain these otherwise difficult to explain observations, the complaint alleged a 3-part conspiracy among medical education's governing bodies. First up was the Accreditation Council for Graduate Medical Education, or ACGME. Because remember, to practice as a physician, you can't just graduate medical school. You have to complete at least some portion of a residency. But for a residency program's training to be considered valid, that residency program has to be accredited by the ACGME. Even the number of positions a program can offer is subject to the ACGME's approval. There's no competition for the ACGME. There's no alternative system or pathway for a physician to complete their residency training. Next came the Association of American Medical Colleges, or AAMC. At the time, the AAMC, through its Council on Teaching Hospitals and Health Systems, or COTH, collected detailed residency salary and benefit data from hospitals and disseminated those data to its members in annual reports. Some years, their survey even highlighted, quote, atypical deviations of institutional salaries from the national averages, which seemed like a tacit suggestion not to stray too far from the pack. Once, the survey even inquired whether institutions might support a uniform schedule for residency salaries. Actually, 70% of the responding institutions answered affirmatively. The final piece of the conspiracy was the match. Now, let me be clear, the NRMP was never alleged to be directly involved in price fixing, but it was the existence of their matching market that was the piece that made it all possible. Because participation in the match was binding, residents could not hold multiple offers and use that as leverage in negotiations. In fact, the match ensured that there were no negotiations at all. You had to go wherever you were placed, if you were placed, and work the hours that they dictated and receive the pay that they paid. At the time, programs were not even required to give you a copy of the contract that you'd be asked to sign. Taken together, the plaintiffs seemed to have a strong case that the entities named in the suit were engaged in anti-competitive business practices that might be in violation of federal law. The lawsuit went off like a bombshell in the world of medicine, in no small part because the stakes were so high. The lawsuit had been filed on behalf of all resident physicians from 1998 to 2002, a class that was estimated to include some 200,000 young doctors. Some simple back-of-the-envelope calculations showed just how enormous the defendant's exposure could be. For instance, suppose that the court found that the difference between the residents' actual wages and their fair market value was just $15,000 a year. Well, at the time, there were 25,000 residents per year, which would end up being $375 million a year in damages. Of course, if the plaintiffs could show that this conspiracy had been in place for 8 years by the time the case went to trial, that would result in $3 billion of actual damages. But that's not all, because by statute, in antitrust suits, actual damages get tripled. That would leave the defendants on the hook for $9 billion in statutory damages, and then you can tack on court costs and attorney fees on top of that. Make no mistake, a judgment like that would be a death blow to the organizational defendants. In 2002, the NRMP had revenues of just $3.2 million. The relatively well-heeled AAMC had revenues of just $56 million that year. I mean, that's a nice chunk of change, but nowhere near enough to cover a judgment that size. But there's one thing I haven't yet mentioned. These organizations weren't the only defendants in the suit. The lawsuit additionally named as defendants no fewer than 29 hospitals that sponsored residency programs, including giants like Massachusetts General, New York Presbyterian, Stanford, and Duke. The decision to include these hospitals as defendants was necessary and logical for 2 reasons. In the first place, although you might be able to convince the court that medical education's alphabet soup organizations had been responsible for executing the conspiracy that suppressed resident wages, the NRMP and the AMC weren't the primary beneficiaries of those non-competitive business practices. Instead, it was the hospitals. They were the ones who got access to a steady stream of cheap resident labor. And in the second place, for the lawsuit to result in anything more than corporate bankruptcies for the AAMC, NRMP, etc., it had to include defendants capable of paying the kind of judgment that the court might return. It had to include the hospitals and their deep pockets. But deep pockets can also buy powerful allies. And soon, the decision to include the hospitals in the suit would prove portentous. As soon as the suit was filed, all 36 named defendants began a vigorous legal defense. To read through the court records from this time is to take a fully immersive bath in dense legalese. Suffice to say, the papers that the parties filed were voluminous. There were motions to dismiss, objections to the court's jurisdiction, and lengthy answers to the suit. The NRMP did have a unique defense, asserting that the match participation contract required that disputes be settled in arbitration instead of court. Merrick was prepared for this. After formulating the case, he'd recruited 16 class action firms to assist with the litigation and keep from being drowned in paperwork. But as the depositions and interrogatories and motions built up in one legal skirmish after another, life got increasingly difficult for the residents. Things reached a crescendo in the winter of 2003-2004, prompting the plaintiffs to ask Judge Paul Friedman for a protective order. And here I want to make an aside. There were times, both as this case was working through the courts and in descriptions of it since, when the residents who served as class representatives were portrayed as if they were ambulance chasers just out to make a buck. So let me be clear. This was a class action lawsuit. If the suit prevailed, all residents would have received the same financial settlement. The class representatives got to take all the heat, and they stood to gain no more than any other resident. Now, back to the story. Because as the case worked its way through the courts, a couple of other interesting things happened. The first was the announcement in 2002 that the ACGME would institute new duty hour requirements. Starting in July 2003, residents would be limited to working 80 hours per week, averaged over 4 weeks. Now, let me be clear, officially this action had nothing to do with the ACGME's pending lawsuit. It is absolutely true that the ACGME had been studying this issue since at least the early 1980s. But I gotta say, the final push to implement the duty hour requirements, it seemed to occur very rapidly, and without any of the usual administrative flotsam and jetsam that actions of this magnitude typically generate. Based on the historical record, or lack thereof, it's awfully tempting to speculate that Jung versus AAMC might have pushed this action across the finish line. It's easy to speculate on why the ACGME and other defendants might have seen this kind of action as being beneficial to their case. I mean, if, God forbid, the case went to trial, descriptions of resident work hours were likely to generate substantial sympathy from a jury. I mean, the average juror maybe doesn't have an intuitive sense of antitrust law, but she probably has a strong opinion about whether she wants a resident in the 35th hour of a 36-hour shift performing emergency surgery on her grandmother. The second development was also telling, especially with the benefit of hindsight. The defendants, especially the NRMP, began a sustained public relations campaign designed to bring more attention to the suit, especially from people in medicine. Normally, this is not the kind of thing you do when you've been accused of orchestrating a vast conspiracy that suppresses wages and leads to inhumane working conditions. But the NRMP and other organizational defendants, they correctly perceived that the match was very popular, and they sought to leverage that popularity to their advantage. This here is a screenshot from a website called savethematch.org as it appeared in 2003-2004. See, you got to remember, by the early 2000s, the match had been in existence for half a century. Essentially, every practicing physician had experienced the thrill of opening their letter on match day. Some physicians in practice might have still been old enough to remember the bad old days of exploding offers and early headhunting by hospitals. In fact, the NRMP's lawyers actually sought an affidavit from Dr. Hendren, the hero of part 2 of this series, to show that medical students had been involved in the original design and implementation of the match process. Thus, through their Save the Match campaign, the NRMP sought to make the suit not about whether the match was illegal, but whether it was good. Despite the sordid allegations in the lawsuit, most medical students and residents agreed that the match should be preserved. The AMA's resident and fellow section formally opposed the suit, noting that dismantling this orderly system without an alternative would be catastrophic for patients and the future of medical education. The American Medical Student Association, or AMSA, whose advocacy had been so instrumental in pushing the NRMP to move to an applicant optimal algorithm, they also chose not to support the lawsuit. On my website, I've included a link to an old 2003 post from Student Doctor Network. It reveals genuine uncertainty about what a post-match world would look like and whether residents would truly be better off. Of course, the court cared little about whether SDN avatars like Whisker Barrel Cortex, Ortho Guy, or Gasman 2003 liked the match or not. The question before the court was a legal one about whether the conduct and policies of the NRMP, AAMC, and ACGME violated federal antitrust laws. And on that issue, opinion was more uniform. They probably did. Here, for instance, is a quote from an analysis of the case that appeared in the Vanderbilt Law Review. The plaintiffs have a strong chance at prevailing on their claim that the NRMP is anti-competitive under Section 1 of the Sherman Act. Overall, defendants' possible justifications for the match appear to be largely policy-based rather than legally grounded. Even if defendants present strong evidence of the efficiencies created by the NRMP, the court will likely find that such efficiencies can exist within a less restrictive structure. So why spend money and effort on increasing public support for the match? I mean, the case was going to be decided based on the law, right? Right? When they analyzed the legal circumstances of the case, the defendants began to see another way out of this lawsuit. Maybe the match did violate the law, but maybe the law could be changed. Soon, rumors began to swirl that the AMC was planning an end run around Merrick and Jung's lawsuit. They were going to lobby Congress to make an antitrust exemption for the match. The New York Times investigated. In an August 2003 story entitled, Medical Establishment Turns to Powerful Allies to Thwart Residents' Lawsuit, the AMC's leadership was surprisingly frank about their intentions to have Congress change the law and make their legal troubles go away. The article also includes this gem of a quote from the CEO of the AMC. It is precisely because the suit has no merit that we're going this route. Because, that's obviously what you do when you're facing a frivolous lawsuit in which a courtroom victory is assured. You call on your buddies in Congress to change the law. But right around here is where the decision to name individual hospitals as defendants in the suit started to look like a miscalculation. Academic medical centers are big businesses. They have real constituencies and significant political capital in their home districts. When they speak up, legislators listen. The hospitals found a particularly receptive audience with Senators Ted Kennedy from Massachusetts and Hillary Clinton from New York, whose states were collectively home to 8 of the hospitals named in the suit. After the defendants hired 2 former Kennedy staffers, Merrick and his team knew that they were going to have to defend their case not only in the courthouse, but also in Congress. So the plaintiffs found a bipartisan group of senators who were concerned about the possibility of backroom deals being made. These senators, Larry Craig, Jeff Bingaman, Russ Feingold, and Herb Kohl, were willing to speak out about it, not because it helped their districts, but because it was bad government. In November 2003, the group sent a letter of concern to Senate Majority Leader Bill Frist, arguing that any legislative proposal having to do with the match and the associated legislation should be subject to the regular legislative process. Things were quiet for a little while. But then, on February 11th, 2004, after nearly 2 years of courtroom maneuvering, Judge Friedman made his ruling on the initial motions. 3 defendants, namely the American Medical Association, the Council on Medical Specialties, and Washington University, saw their motions to dismiss approved, and they were released from the case. But for the rest of the defendants, including the NRMP, AAMC, and the vast majority of the hospital defendants, the case was going to go on. It looked like Merrick and Jung were going to get their day in court. But then, on April 8, 2004, the Senate took up a bill called the Pension Funding Equity Act of 2004. In many ways, this is a completely mundane piece of legislation. It's a dreary, technical bill whose principal focus was to change the interest rate used to calculate employee pension contributions. But when the Senate took up the bill, they were under a bit of time pressure. If a new pension funding bill was not approved by April 15th, employers would be left without any guidance about how to calculate interest rates for their pension plans. The House had agreed to the Senate version of the bill. All that was needed now was for the Senate to pass it along to the President. But when the bill came to the floor for a vote, some senators read it and observed that the bill's sponsors, Senator Kennedy and Judd Gregg from New Hampshire, had attached an extra amendment to the bill. It was entitled Confirmation of Antitrust Status of Graduate Medical Resident Matching Programs, And it was explicitly stated that the purpose of this amendment was to confirm that antitrust laws do not prohibit sponsoring, conducting, or participating in a graduate medical education residency matching program. And further, this bill was intended to ensure that those who sponsor, conduct, or participate in such matching programs would not be subject to the burden and expense of defending against litigation that challenges the matching programs under antitrust laws. When he took the floor, Senator Feingold criticized the way the amendment had been pushed forward. I wanted to discuss one additional provision of the bill that has not received much attention in this debate because it was not part of the bill until just a day or two ago. I'm very troubled by the 11th hour addition to this conference report of a provision that purports to grant antitrust exemption to the graduate medical resident matching programs. We've had no hearings on that issue in the Senate Judiciary Committee, and no language has ever been presented to the committee or to the Senate. For the managers of this bill to insert a controversial provision with no Senate debate or discussion is the worst way to legislate, particularly in the complicated area of antitrust law. Senator Cole was even more succinct. It appears that this provision, enacted in this way, is nothing more than a giveaway to one particular special interest. Senator Bingaman was similarly scathing in his remarks. The antitrust exemption raises grave constitutional concerns. There's been no justification presented to this Congress for depriving medical residents the same protection under antitrust laws that are enjoyed by other workers and other Americans. I do not see how it is constitutionally permissible to take away the equal protection and due process rights of medical residents without any showing that is necessary or beneficial. But it was all too little too late. The fact was the Senate needed to get this pension business taken care of, and few lawmakers were willing to die on this hill. The measure passed 78 to 19, and 2 days later, President George W. Bush signed it into law. And so, on August 12, 2004, Judge Friedman issued his final order in Jung versus AAMC. Noting that Congress had spoken, he dismissed the suit. Now look, to exempt an industry from antitrust is not without precedent. I mean, look at Major League Baseball. But to bring it about by a clandestine 11th hour amendment without any real debate or broader consideration was decidedly unsavory. Now, nearly 2 decades later, Jung versus AMC has largely been relegated to a historical footnote, and a largely unsatisfying one at that. For the defendants in general, and the NRMP in particular, the outcome of the suit was a big victory. Although the match could still unravel, the Pension Funding Equity Act of 2004 secured the match's legal position for the foreseeable future. For the plaintiffs, the outcome was a huge loss. Here, I want to point out again that as class representatives in a class action lawsuit, Drs. Jung, Lorena, and Green stood to gain no more than any other resident. They didn't do this to get rich. And after years of serving as the lightning rod for criticism, they walked away with nothing more than a civics lesson and a bitter taste in their mouths. The plaintiffs' attorneys were big losers too. Unlike the defense attorneys, who billed an hourly rate that culminated in $500,000 a year of bills to their corporate clients, the firms backing the plaintiffs took this case on contingency. They earned exactly nothing for the untold hours they put in. For Sherman Merrick, at least, there was a silver lining. His leadership established his expertise and launched a career leading one of the few law firms in the country that focuses almost exclusively on legal issues affecting medical students and residents. For those not directly involved in the suit, the wins and losses are harder to tally. Although the evidence is circumstantial, I do think that the implementation of the ACGME's 80-hour work week was at least a little bit accelerated by the lawsuit. The lawsuit also led to a new NRMP rule requiring programs to provide a contract to interviewees upon request. But beyond these winners and losers loomed an unanswered question, the biggest question that the lawsuit raised. Would students and residents be better off without a match? Despite 2 years of legal grappling and political maneuvering, the courts and Congress managed to sidestep this question. But I won't. In part 6, the final part of this series, I'll take this question head on. Thanks for listening.